Good afternoon, everyone. I'm Karen, an organizer with Warehouse Workers for Justice. I'd like to welcome you all to another Know Your Rights workshop. And today we'll be reviewing the process of sealing and expunging records in Cook County. Let's start with a disclaimer, all the materials that you'll see today have been prepared for general information purposes only. They're not to be taken as legal advice, but if you do have any specific questions on your case, feel free to contact us, and our hotline is on the screen. And so the reality is that today, millions of people across the United States live with barriers and stigma of a criminal record, no matter how big or small their record might be. For many, that means that they're deprived of better work and housing opportunities, education, as well as improving economic conditions. So why is it important? By expunging your record, individuals such as landlords, employers, banks, credit agencies, and others who can lawfully conduct a search of your name will not see the record that has been expunged. And just as a reminder, this resource is completely free through Warehouse Workers for Justice and our partnership with UIC. I know many of you are wondering if you're eligible for expungement or sealing of your record, and it depends. You might be able to do both or one or the other. So that's why today we have staff attorney Sarah Sellen from UIC School of Law joining the conversation today. Welcome, Sarah.
Thanks, Karen. Hi, everyone. Like Karen said, my name is Sarah Salen. I am from UIC Law. I work specifically in the pro bono litigation clinic, and I work with students, and part of our job is that we partner with WWJ and we offer sealing and expungement services. So I'm excited to be here and provide some information and hopefully get to work with you in the future.
Thank you, Sarah. We also have Janelle White here, the director of the Temp Worker Union Alliance Project. She brings extensive experience in the labor industry and the struggle that workers face to fight for better conditions in their workplace and also in their communities. Welcome, Janelle.
Thank you so much, Karen. It is my pleasure to be here to represent TWOP, the Temp Worker Union Alliance Project, and I am also happy to have the opportunity to hear what Sarah has to offer to all of our viewers. So I briefly want to tell you guys a little bit about what TWOP is. So again, it's the Temp Worker Union Alliance Project, TWOP. It's a project, not an independent 501c3 just yet. I like to call it the little project that could. So basically, what TWOP focuses on is advocacy for temp workers. And we do that by providing resources and knowledge and information about any laws that are in place and that exist to provide them protections from workplace injustices or unfair treatment in the workplace. So again, I'm happy to be here. We do partner with unions, just similarly to worker centers. We do organize around workplace issues that directly affect temp workers. And then if there's an opportunity to forge a relationship with the union and help temp workers to organize their workplace, then we're also on hand to help facilitate with that process as well. If you'd like more information about TWOP, I definitely encourage you and invite you to visit our website. That's uap.org, twop.org. Thank you, Karen.
Thank you, Janelle. And so we'll have our conversation today about all the questions around sealing and expungement. Sarah's going to answer all of the questions. So thank you both for being here today. And before we get started, I just really would like to provide more details on the partnership that WWJ and UIC have. So UIC Pro Bono Litigation Clinic and Warehouse Workers for Justice have joined a partnership to process these sealings and expungements in the Cook County area. So it's really important to highlight that law students process these cases, and of course they're supervised under very experienced attorneys as Sarah. And of course the goal is to gain experience as they also help community members, which is something that we are very grateful to be able to provide. And again, this program is only possible through UIC and their law students. Is there anything else that you would like to add, Sarah?
No, just that it's a mutual benefit. Our students get to learn and work as attorneys on these cases and also get to provide this really important service. So this is one of my favorite things that we do. And we'd like to continue to work with WWJ with this partnership.
Thank you so much. So let's dive right in. Janelle? Oh,
Oh.
1 second. So before we get into the details, here are some statistics on the benefits of obtaining an expungement. And so the University of Michigan Law School drew a study, right, on what the workers see and improvements in their lives. So about the probability of employment actually rose by 6.5, and wages also rose in a 22%. In addition, fewer than the 4% of the participants were arrested within 5 years of having the records cleared. And then a similar study in California also discovered that participants who have their records expunged have reported an average increase in their yearly income of up to $6,000, which means that you are not only clearing your record, but you are obtaining better job opportunities, housing opportunities, education, and of course, improvements in your finances. Alrighty, so hope that's information that's helpful. So let's dive in.
All right, thank you, Karen. So we're gonna keep this sort of conversational. As organizers who are on the ground and have, firsthand contact with workers, we kind of, are going to be asking these questions from a worker's perspective, Sarah. And, also, if we do have live viewers, you're a worker and you have questions for Sarah, we do invite you to leave those in the comments as well. So without further ado, I'm going to dive right in. So first question for you, Sarah, what are the options to clear someone's criminal record in Cook County?
Sure. So in Cook County for filing petitions, there's, as most people know, expungement, and there's also sealing. So expungement is the physical destruction of the record. It's like it never happened. The clerk's office will actually impound the record. No private or public entities can view the record, and it will not come up on a background check. Expungement, we might go into it later, but expungement is only available for non-convictions. So those are cases where you were arrested, but the charges were dropped, or you actually released without charging. There are a few types of sentences that are actually non-convictions, but that's what expungement is, and that's the best, but it's only available for non-convictions. Sealing is exactly what it sounds like. So the record cannot be seen by the general public. Only employers that are required by law to do a fingerprint background check can see sealed felony convictions. So this might be a hospital or a school or an organization that requires work with or around children, fire departments, police departments. Landlords will not be able to see a sealed record. Law enforcement agencies such as police departments, the state's attorney, a prosecutor, they can view sealed records. And sealed records cannot be accessed without a court order. And sealing is what is available for conviction. So if someone pled guilty and either did time in prison or were on probation or did boot camp or something like that, those are the options. And those are the types of petitions that we file in Cook County.
If I may, can I ask a follow-up question?
Sure, please.
Okay, so I personally have come into contact with a lot of workers that have been convicted of misdemeanors.
Yep.
Would that be something that would qualify for them to go through the record expungement process?
Oh yeah, so we always tell everybody, if you have had contact with police or been arrested, you have a record and we can likely do something about it. So we encourage you to connect with WWJ and get the documents together so that we can look into it and work with it, because absolutely we are often and I think we might talk about it again, but we're often cleaning up a lot of records, and we're looking at misdemeanors, at felonies. We'll talk more about what is eligible and what's not, but 100%, if someone's like, it's just a misdemeanor, people can still see those records. It's public record right now if you haven't done anything. So that is definitely something that is eligible, and we definitely do all the time.
Great, thank you, Sarah.
Thank you.
Okay, so next question. What if a person has a cannabis conviction on their record? What are their options?
Yeah, so great question. So I think January of 20, I believe, so I think that's when it was, cannabis is now legal in Illinois. So there was a new change in the law about being able to seal and actually vacate, which means actually turn, if you had a conviction for a misdemeanor or a class 4 felony, that you may be eligible to vacate that conviction, which means delete it, take away that conviction, and then expunge it. So these are things that we look into. There is some might have heard there's some automatic expungement when it comes to cannabis convictions, but that hits only a few things. So sometimes people are like, oh, I just have cannabis on my record, they're going to take care of it. I still say everybody should reach out to us because we can actively look at it. And but either if it is a cannabis conviction, we either will do it according to the normal, like run-of-the-mill sealing or expungement petition, or there's these special motions to vacate and expunge it. So we are dealing with that every day, and the courts now are very familiar with this type of petition. So it's been much smoother sailing since we have started doing this.
Great, thank you. Okay, so next question, and this one might be a little bit tricky because our workers sometimes move around, so let's say they have come into contact with law enforcement in another state, and then they've relocated to Illinois, and they're trying to get opportunities for work, and when they get the background check back, employers are not hiring them, or they're having issues with even getting approved for a lease for an apartment. What would you advise someone to do if they have a record from another state?
Yeah, so unfortunately, record relief, sealing and expungement of records is really state specific. We can only touch Illinois records, and specifically, we only practice in Cook County. However, if you have other arrests outside of Cook County, we either provide referrals, as well as I know WWJ has specific partnerships with other organizations out in different counties. But if it's out of state, a few things are important for us to know because it could impact your Cook County record, is just to know like when the record happened and if it's still open, because that might impact someone's eligibility. But if they do have record from out of that state, they will have to contact an organization in that state. And where we often recommend people to look at is the attorney bar organization, or to look up a legal services organization there, because you'll have to go and file in that state. That's where there's jurisdiction, where you have the power to do something. So it won't come up if you're just doing a local background check, but if they're doing the, state, like if they're doing your whole background check, then that will come up and they will have to deal with that out of state. I will say we get contacts from people that are living in different states that have Illinois records, and we are able to work with them. But they will have to, go to that other state or contact someone. A lot of things are now happening virtually. So, hopefully it will be easier than that, than having to go back there. But that's something to consider.
Okay, great. Thank you, Sarah.
Mm-hmm.
So now that we've determined the difference between expungement, sealing, and other types of convictions, the first step would be to obtaining a copy of their criminal record. Correct, Sarah? And if so, how can someone obtain a copy of those records?
Sure. Yeah. So in Illinois, we need two records. We call both of them your rap sheets, but we want your Chicago rap sheet, and rap sheet stands for Record of Arrests and Prosecutions. And this lists, all the arrests and charges that definitely happen in Chicago and often within Cook County, because many of the Cook County police departments report into the program that the Chicago rap sheet pulls from. But you also need your Illinois State Police report, which is the statewide report that should show all of your arrests in the state of Illinois. And this happens, the easiest place and the place we recommend for everyone to go is to Chicago Police Department headquarters at 35th and Michigan. You do have to go downtown and get fingerprinted. They just changed their hours. I think they're open Tuesdays, Wednesdays, and Thursdays for the beginning portion of the day. So unfortunately, it's not the most convenient, but it's worth the trip. You will get fingerprinted. The cost is $16 to get those records. And it takes about a week or 2 weeks to get everything back because they do have to send your fingerprints out. But then with both of those records, then, that's what Karen, you do, you process it and send it to us so that we can start diving in and looking at the case.
That's right. So like you mentioned, this does have a cost of $16, but people often wonder, what is the total cost that they can expect to pay, right? If they were to go to a private attorney, it would be somewhere in the $1,000. However, when you're doing it through a nonprofit, it's completely different. Could you tell us a little bit more just about what other cost in addition to the rap sheets could people expect?
Sure, yeah, of course. So just like you said, Karen, so we're fortunate. We're the pro bono litigation clinic. So we do not charge for any of the hours and hours that we spend analyzing these records and for my students calling and talking to people. We do not bill for anything. Everything we do is pro bono, so for free, which is wonderful for completing the documents, for filing and everything. There is that $16 fee, as we talked about, for the rap sheets. If someone has a drug-related conviction, they will need to complete a drug test, and that drug test needs to come back. We need to have a clean one within 30 days of us filing. And we have found a place that's the most affordable is $25. And people sometimes choose to go elsewhere, but that's the most affordable that we have found. That we can't pay for outside fees, so that would be the cost for a worker to expect. And then the last is there's a filing fee for every petition that we file. However, if you qualify for a fee waiver, which we can determine by looking at someone's income and the amount of people in their household, then that is waived. So it depends. We'll take it case by case. But if someone makes over a certain income, there might be filing costs associated with it. And that's a conversation that we have with the worker if it comes down with it. But generally, to get everything started, it's just that $16 and maybe the drug test, and then nothing for all of the services and work that we do on the case.
All right. So I know earlier, Sarah, I asked you about an instance where someone might have have encountered law enforcement in a different state. But now I want to ask you a question about what do people do when they've had an encounter with law enforcement in different counties within the state of Illinois?
Oh, yes. Great question. This happens often with people we see. So you will have to file in that county. Again, we as UIC, Chicago Law School, we only practice in Cook County. As I said earlier, that we have some partnerships, or WWJ does, and we have some referral services to different counties. What we can do, why we get that Illinois State Police report, is we often, that sometimes reflects out of county arrests, so that we can just flag it for someone that they are going to want to follow up with a different organization. They will have to use that organization because as a Cook County organization, we only have access to the internal Cook County records, and I can only see the court cases and what happened. So you need to go to another county organization in that county to file, so that make sure they have a complete view of your record and that they complete the petitions and then file the paperwork there. If there are any hearings or anything, then they'll make sure to go to those hearings in that county. So it is a complete different, it's the same process that we have, but you will have to do it separately with, filling out a petition and filing. And if there might be any of those fees, or if there's another drug, you can often use the same drug test, so that's fine. But they will have to, the other county organization will have to review and do the same work that we do for the petitions in Cook County.
Okay, thank you. So my next question is, are there scenarios where someone would not be eligible to expunge their record?
Sure.
And if so, what are they?
Yeah, so I guess the biggest one right now is one cannot file on anything, sealing or expungement, if they currently have an open case or any pending charges against them. So if they have, were arrested and they're pending, they have court cases in the future, or they're currently, on probation or parole or court supervision, then they are not eligible to file on anything, sealing or expungement. However, there are certain wait periods after, before one can file to seal convictions. There might be a wait period, sometimes of a few years. So if there is a wait period for certain offenses for the sealing, then they might have to wait on the sealing, but then we can, as long as there's not an open case, we can file on all their non-convictions to file to expunge them. So that is also a really important part of why I love this partnership. Is often we get, some people think that they can't do anything because, it hasn't been long enough, but we can already dive into their non-convictions and get all of those taken care of while we're waiting for their wait period to be done. But if you're currently on some type of sentence, then we can't file on anything. It's a complete bar to file at this time. But once that case wraps up, then they should contact WWJ and get in that line so that we can look at the record.
Okay. And I know you kind of touched on it briefly in answering the previous question, but I wanted, if we could take just a little bit more time to specifically talk about, which records can be expunged and which records cannot be expunged, because oftentimes, when folks are facing that challenge, they're not really quite sure if they can or can't.
Yeah, so, it's actually easier for me to start with what cannot be expunged, because and that's what I feel like I'm often educating people, is people think that something on the record is not able to be sealed or expunged. I want to correct our, it could be sealed if it's a felony conviction, or sorry, just a conviction generally. But things that cannot be sealed or expunged are minor traffic offenses. These often are not barriers anyway to anything, but minor traffic, DUIs, so driving under the influence, even if you were given supervision and completed it, there's no sealing or expungement for a DUI. Reckless driving convictions, except if one is a youthful offender, which we can look at on the record. Domestic battery convictions. So if you were convicted, some people are arrested and there's no conviction, but if there was a conviction for a domestic battery. Violations of orders of protection. Sex offense convictions cannot be expunged or sealed except for prostitution and misdemeanor public indecency. And animal offenses, more serious animal offenses, so Class A misdemeanors or felonies, cannot be sealed or expunged. So maybe sounded like a long list, but you can hear I didn't say, armed robbery. I didn't say, there's a lot of things I didn't say, and those all can be sealed or expunged depending on, if we remember, if it's a non-conviction, that's expungement. It's a conviction, it's sealing. It is discretionary, so it is up to the judge, and that's why we like to work, that you work and have an assigned attorney or student attorney working with you, because sometimes we do have to go to court and make an argument and show all the great things, how someone's changed their life, and we have to gather some documents to make an argument, but ultimately the judge makes the decision, so it's not a guarantee, but you'll hear of that list that everything else is in the running and can be filed on.
Okay, great. Thank you for providing that clarity. So another sort of related kind of follow-up question. What if there's someone who has encountered the law and has both types of offenses, like a misdemeanor and a felony? How would they navigate that?
Yeah, so actually the difference, misdemeanor and felony for the most part doesn't impact, determining eligibility. It's more about if they've been convicted or not. So that's what my students do, is we will look carefully at the record. That's why we need the detailed record. And then we go into look at the court cases to see what happened in the case. So we will determine, if they're, what is eligible for sealing, what is eligible for expungement. Sometimes, as I kind of mentioned earlier, if someone's in a wait period, for example, there's often a wait period after, so for example, for most convictions, it's often a 3-year wait period after completion of the last sentence. So even if I was convicted a few times, it's for my last conviction for the wait period for all of it sealing. So if I am in a wait period for sealing, we can still jump ahead and file an expungement. So we might file on a lot of your one's non-arrests and then say, okay, come back and contact us in 2024 when you're out of your wait period, and then we hopefully can jump in and help you file on that case. So even if say you have something that I told you earlier that's not eligible, say there's a domestic battery conviction, that doesn't impact your eligibility. That doesn't mean because you have something that is not eligible, if there's other arrests on one's record that is eligible, then we can file on those. It doesn't mean it is not a bar for then removing the other parts of the record. And we often encourage, just because of public access, we often encourage it is good and helpful to clear things off your record that do not need to be there, especially the non-convictions, because when people look at rap sheets and records, they don't know what they're looking at. They assume that they often assume people did it and they judge people for it. And even if they did it, there's often a lot more to that story, but there is a lot of value to getting anything you can off your record, even if some things have to remain.
Thank you. It's really helpful to get this perspective that we don't usually see. Often people are nervous, they really don't know what to expect. So it's really good that we have you here, just sharing your personal experience with so many cases. And now that we've touched based on how to obtain rap sheets and then determine eligibility, right? Like people wonder what's next. And usually they're very nervous about this process. And there's so many questions that people want to know because, they also want to plan ahead for their future. Some of them are very eager to have their record cleared. So I would say one of the most asked questions is really how long can they expect before their record is finally sealed or expunged?
Sure. So when they start, the first step is they'll interact with us. They have to do an intake with a student attorney. We have to do the proper things on our end to make sure we can take on the case, and then get them to sign the retainer, which starts the attorney-client relationship. Once they're onboarded, and we will have a meeting with them over Zoom or in person, depends on what works for everybody. Then we jump in and start working on the case and analyzing. And it can take some time because there's a lot of attention to detail that we want to make sure we get right. We look at the entire Chicago rap sheet, the entire statewide rap sheet, any court cases, And we create this huge chart, and make sure that we have all the numbers right. And, an 8 is not a 0, and make sure everything is perfect. And then we figure out one's eligibility. And then what we do is then put it in writing and send it to the worker, outlining all their eligibility. What is eligible? What is not eligible? If there is a wait period, what is in a wait period, and when that wait period ends, so you have in writing your entire record, the analysis of your record, and what you can do. And then once that is sent, then we start jumping into the petitions. Now, there might be several petitions that have to be filed depending on one's record, because in Cook County, there are 6 filing districts. So it depends on which police department was the arresting agency, which police department that determines where we have to file. For example, Chicago, which is the most popular police department, that's in District 1, but there's others. Again, there's 6 filing districts. So we have people all the time that have petitions in all 6. So once we complete that petition, we send it to the worker to approve it. I sign as because I am the attorney of record, so I'll sign the petition and we file it. And then it takes time depending on the filing district. So in District 1, the most popular, so it has the biggest backlog. It can take, without us, it can take almost a year if you didn't have our help, but we have some opportunities where we file it, and then we can file a motion several months later to try to get an earlier court date. So it can take around, typically it can take like 4 to 6 months in Chicago. In districts 2, 3, and 5, you will file, and we won't hear anything unless there is an objection to the petition, and then we'll have a court date and represent you at that court date. We typically hear back in about 3 to 6 months from filing. So remember, we've done some work before, but this is also from filing. And then the last 2 districts, District 4 and 6, we get a court date immediately upon filing. So they just set one no matter what. And that's typically a few months out. It's like 2 or 3 months out from our filing. And we'll know either a little bit before on that day is if there's an objection, and we'll make sure we prepare, or if there's not one, then it's often granted on that day. So generally, again, it depends, but it takes about, generally from filing about a 6-month process before it's sealed or expunged. But then what's important in the law is once there is an order for sealing or expungement, it gets sent to the arresting agency, so whichever police department arrested, the Illinois State Police, because they also keep a record, and then the court clerk if there's a court case. And those 3 entities have 60 days to delete the record, or delete or seal the record, depending on if it was sealing or expungement. So they have to follow the order. Often we follow up with them to make sure that they followed the order. So it takes an additional 60 days. Understandably, they do other things just other than sealing and expungement. So it can take about, an additional 2 months once you have your order to have that record come off in whichever way, whether it's sealing or expungement.
So Sarah, now we'd like to transition to next steps. Like once someone has started the process for expungement and sealing, will they have a court date for a sealing case? How does it work for them at that point?
Yeah, thanks, Janelle. So I just mentioned this a little bit earlier. So it depends if there's going to be a court date. If there is a court, again, in certain districts like 4 and 6, and often 1, there might be a hearing no matter what. If you do this partnership, if there's not an objection, we will advise you of your court date, but you do not have to go. We will go on your behalf because we are your attorney and let you know what happened. If there is an objection, we'll need to work with you to prepare a hearing. We will argue on your behalf. I mentioned it a little bit earlier, but that means often we're gathering great information about you, asking you to get character reference letters, from a pastor or someone from WWJ or from, your employer, ideal, that says all these great things about you, or if you have any certificates that we submit to the court. And then we'll argue and represent you. We always, prepare you if you want to say something, or sometimes the judge, if the judge says something to you, we will step in on your behalf, but the judge might have some questions that the person with the record is the best to answer. But again, we're there to support them and can always intervene. I've never had to intervene because it's a very, the judge normally just looks to the attorney to do the speaking. But we will go to those court dates. Again, it just depends. We file the petition, so we're either going to go to court or we just follow up with the petitions and see if there's no objection. We just make sure that we get the order and then make sure the organizations comply with that order.
Okay, thank you for revisiting that. We just want to make sure that everybody, whether they're watching it live or catching the replay, they get as much information as possible, which leads me to my next question. So we know that Illinois is marijuana friendly for recreational use. So a concern that workers might have is, will they have to take a drug test at any point during this process? And how would that affect them continuing with getting their record expunged?
Yeah, so you will, if someone has a drug related conviction, we will need a drug test. And it has to be taken 30 days within filing. So if it has to be a clean drug test. So if you took a drug test and I file on the 31st day, then it's no longer good. So it has to be good. So we often work with the worker saying, we need it 30 days before. We'll tell you about when we need you to go so that we have a clean drug test in hand that becomes part of your petition that we go to court and file. Often so far in the beginning, we didn't know how judges would look at marijuana coming up on drug tests. So far, I have not had any issues with it. We just tell workers if they're able to refrain from it, it's always best to have a completely clean drug test. But if it's not clean, it is legal. We will argue it. I've never had to argue it yet. I'm always prepared to. I have submitted petitions with positive marijuana tests, but negative all the other substances, which is really what they're looking at, and we have been fine. So again, I can't predict the future. We will always encourage workers, if they're able to have a completely clean, that's going to be the gold standard. But again, that's exactly right, Janelle. Marijuana is legal here. And so far, we haven't had any issues.
Thank you, Sarah.
Yeah.
So our next question is about the pros and cons of filing or starting this process yourself, or using an attorney and going through a referral process to a service such as the work that you're doing at UIC Law. If you could just take a couple of minutes to talk about the pros and the cons.
Yeah, so I think, so the pros, if you want to do yourself, is that it can be very empowering. You're looking at your record and doing everything. But it is really hard and crazy attention to detail. My students every semester, when they're learning how to do this, they often turn to me and say, I cannot believe that people do this on their own, because it can be very complicated. There's a lot of paperwork, a lot of weird codes that you have to look at. So that's why we're here. And that's why I love providing this service. And I do, we're here to provide and look at the record and make sure that we have the best petition prepared, as well as then if one goes to a hearing, that we help structure an argument that best presents to the judge, a great argument about why someone should have their record sealed or expunged. I will say, actually, today I had a hearing for a WWJ person, and I am very confident that if we weren't there representing them, I don't know if it would be granted, just because it was someone with a very long history, but they've completely changed their life around. But I don't know if, unfortunately, I don't know if they didn't have an attorney, I'm not sure that it would be granted. And that's just because this is our profession. This is what we do. Our whole job is to craft an argument. We have the legal training about what judges look at and how to structure it. So we're here to support you when we get your input, to create that argument. But we support you from the beginning to the end and make sure that the record is followed up on. So, you know, the pro, I would say there's just many more pros to go with us, as well as we're not charging any fees or anything like that, but we follow the case until it's over and make sure that it's completely taken care of from beginning to end.
Thank you, Sarah. I mean, right. Honestly, why not? If there are agencies and organizations that are providing this service, you know, for free, take full advantage of the resources. So one more question before I turn it back over to Karen. So you've talked about court dates kind of throughout the course of our conversation here today. We know that during the pandemic, a lot of these things were happening virtually. So I guess we want to ask from a worker's standpoint, do they need to be prepared to physically go to court, or is there still an option for them to attend virtually?
Yeah, so fortunately, I think for us, all court, and at least in Cook County, everything is still available via Zoom, which I think has actually provided really great more access to people. There is sometimes we do have to work with workers to set them up on Zoom, and WWJ has been really helpful because if one's not familiar with it, they'll often, you know, get them in front of a computer. You can go meet with a worker to make sure that they're able to be there. Again, like I said, we'll let the worker know if they need to attend court. They always have a right to, but some, if they don't have to, understandably, will opt out of it because of a lot of reasons why they don't want to attend court. But if you do need to attend, if we have an objection hearing and we need you to attend because the judges like to see the person that is requesting the record to be sealed or expunged, we'll make sure you're prepared. If you need to speak to the judge, we'll make sure to, you know, work with you if you want to prepare a statement, or if we can help you, you know, just get a few bullets of what to say. Again, we will do the majority of the talking, if not all of the talking, but we'll really prepare you. And, you know, if someone's nervous or wants to talk to us, that's what we're here for. And that's what my students love to, you know, they're here day and night to, you know, make sure that everybody's set up. But fortunately, right now it is via Zoom. I believe there is an option to go in person if people want to. We still go to everything via Zoom, but again, if someone wanted to go in person, they're able to do that. And then we just kind of have, you know, the person would be there and we would be on Zoom and be able to take care of it that way.
Awesome, thank you. So my next question is geared to, you know, the population here in the U.S. Many of them are not necessarily a citizen yet. Some may be transitioning from a resident, or they might be in a visa application process, right? So for those who are not yet citizens, do you have any particular advice? Can they expunge and seal their records?
Yeah, so they're absolutely, being a citizen or not, there's no bar to filing, sealing, or expungement. But I do not practice immigration law, so I always tell someone to talk to an immigration attorney before they consider filing, because of several reasons. One, if you seal or expunge your record, especially expunge, as I said earlier, that destroys the record. That means it no longer exists. And sometimes USCIS needs to see that for further applications. So that just might be that you need to have a lot of copies of your record and make sure that, you know, they're in a safe place if you have to provide it in the future, because USCIS gets to see sealed, like they get to ask about sealed or expunged records. And again, you know, you're getting a fingerprint background check, so it just you know, might alert people of, you know, their if you're getting fingerprinted. But I will say, I work with people all the time, especially someone if they're applying, you know, for their to become a legal permanent resident or a visa. We have people, once they've talked to their immigration attorney and they want to apply, and it's great, then we go forward and do it. But we definitely say you should talk to an immigration attorney before you decide to proceed with this process.
Wonderful. That's very helpful to know, and I think that answers a very frequently asked question. So now we're going to jump a little bit into Janelle's area of expertise. And Janelle, if you don't mind providing additional information on the impact specifically to temp workers on how expungement, sealing expungement might help them. What is the benefit? And at the end of the day, why should they also consider going through expungement or sealing if they need to?
Absolutely. Thank you, Karen. I'm happy to. So I mentioned a little bit in my introduction. I talked about some of the barriers that temp workers face when they're trying to transition away from temp work, precarious, not guaranteed employment, to permanent guaranteed employment, or what we would call a direct hire. And oftentimes there are a lot of compound issues that temp workers face. It can be a combination of, their immigration status, or if they have a record, and oftentimes, they're told by employers, well, hey, I would love to make you full time, but, you don't have your papers, or you have this record. And, it could be something as simple as just talking to the right attorney, being pointed in the right direction to all of these resources that are readily available. And that is why having these partnerships with worker centers and agencies and organizations that provide these services is so important. So I just want to take a couple of minutes before we go here today to kind of educate those who may be unclear about exactly what discrimination is, because as I stated, we hear this time and time again, story after story after story, about workers facing these injustices in the workplace and not knowing that they have the right to seek representation and file complaints and have someone advocate on their behalf to put a stop to these workplace injustices. So really quickly, what is discrimination? So the textbook definition: facing adverse employment actions based on a protected group. So can someone face discrimination because of their criminal background? As I stated before, a lot of times, they're having barriers to having a better job, and in turn, a better quality of life. Oftentimes, temp workers do the exact same work as direct hires for less pay and little to no benefits. So can you imagine working throughout this pandemic and not having access to healthcare, or not having access to PTO, paid time off, having to, choose between going to work so that you can make enough money to pay your rent or your car note or your bus fare or care for your dependents and your loved ones, or staying at home and caring for yourself when you've fallen ill, or caring for a loved one or a dependent who's fallen ill. No one should have to be faced with making that decision. So that's why we, fully at TUOP want to support temp worker advocacy and temp workers, being knowledgeable about their rights and having access to information and services that can help fight their battle for them. Some other instances where temp workers may be facing discrimination. It could be based on their race, ethnicity, their color, their religion, their sex, sexual harassment, that unfortunately is still a thing, their nationality. We have a huge population of temp workers are migrant workers and immigrant workers who may or may not be going through the steps to try and gain their citizenship, but in the meantime they still have to make a living and still have to support themselves and their loved ones. Pregnant women, sexual orientation, their age, and if the worker has any disabilities. So if you or someone that is out there and you're watching and you're a temp worker and you feel that some of this may be applicable to you, we want to invite you to reach out to us at TUOP and or at Warehouse Workers for Justice. We are happy to refer you to our network of attorneys, and hopefully, we can get you some relief to your situation. So in absence of having a lawyer, I want to give you guys some tips for best practices if you feel like you're being discriminated against in your workplace. First and foremost, keep track of all incidents. You want to take notes. Everybody's got a smartphone. It could be something as simple as taking a second on your break to pull out your phone and type what happened, an exchange, or whatever your experience is. If you have a notebook handy, write it down in a notebook. You want to be sure to include pertinent details such as dates, names, what was said, where an incident took place, like in the facility. Like if you're in a warehouse, for example, and you were on a particular line during a particular shift, like all of those details. There's no such thing as too much information, especially when you may be seeking a legal representation. Always follow the company's anti-discrimination or anti-harassment policies, and if you're not sure what those are, you can ask your supervisor or ask an HR personnel to give you copies of that or send it to you. If the company does have a policy or a procedure regarding discrimination or harassment in the workplace, the worker should absolutely follow that procedure to the letter. In the absence of a company policy or procedure, you want to make sure that you notify your manager, supervisor, or human resources personnel, or even the owner when applicable. So let's say the offending party was your manager. Well, then you probably want to go to HR. If the offending party was HR, then who's over them. You definitely want to follow the chain of command when you're trying to report it to seek resolution to the issue. Always try to notify the employer in writing whenever applicable. Again, we've all got these smartphones. Make sure you have an email address set up so that you can use it for things like this. Not necessarily your personal one, but the one you use when you're applying for jobs. And just make sure that you are emailing it, whenever possible. If you have access to a computer and a printer, if you can print out a hard copy, that's fine as well. Just make sure you keep a copy for your own records. And if the notification is verbal, then you want to make sure that you bring along a witness. And that could be as simple as bringing one of your coworkers with you. Just, oh yeah, so-and-so's just here as a witness because I am, telling you about an incident that happened. And again, to reiterate, document who your witness was, document the day and time that it happened. So now I want to talk about the Civil Rights Act. Title VII of the Civil Rights Act of 1964. So this protects workers from discrimination. An employer needs at least 15 employees to be covered. So if you're at a company that has a smaller number, we might have to find something different for you, but this usually is applicable to larger work sites. So this prohibits harassment, including sexual harassment. To file a federal or state discrimination claim, a worker has 300 days from the date of the violation to file their claim with the EEOC, IDHR, or CCHR. And for all of those organizations that I mentioned, especially like such as EEOC, go to their website. Read up on which cases they might be willing to take. A lot of these agencies and organizations have a form online that you can fill out. Oftentimes these forms are available in multiple languages, so if there's a language barrier, go on there and find it in the language that's applicable for you. Call, make an appointment, reach out to them. All of these agencies and these organizations exist specifically to help folks who are experiencing workplace injustices. So I hope this information was helpful to someone. And again, if you all have questions or concerns, we definitely invite you to reach out to WWJ or TUOP, and we'll take it from there.
Thank you, Janelle. Lastly, I would like to remind everybody that Warehouse Workers for Justice has several resources. We have several community legal partners and agencies that help us do this important work to get you guys legal help if you are in need. And so in addition to expungement, we do have those resources available in Cook County, Will County. If you do have anything in the neighboring counties of Will County, we might be able to take it. Driver's license reinstatement, problems at work, if you're experiencing wage theft or you need help with workers' compensation. And of course, we also have referrals to other agencies and community partners for locating rental assistance and utility assistance. So please reach out to us. And here is our phone number, our website, and of course our handles for social media. So if you need expungement, sealing, now you know what the process is. Sarah, thank you so much for walking us through the entire process. Janelle, thank you so much also for bringing your perspective for temp workers. Ultimately, records are not something unique to workers. Anybody in our community can be facing issues because of their record. And so we just want you to have access to better job opportunities, housing opportunities, and for you to see an improvement in your life. And hopefully we get that opportunity to help you. So thank you both for being here. And we'll see you next time.
Thank you, Karen.
Yeah, thank you.